Thank you and welcome again. As always, we have some preliminary housekeeping matters. Our good friends here at First District Court of Appeals let us use their facilities, so we ask that you respect their rules and have absolutely no food or beverage other than water in the chambers here. Please also silence your cell phones, which is a good reminder. I think I'll do that while, thinking about it. Anyone addressing the commission and commissioners, we ask that you please speak up so that our recording equipment may pick you up properly. Commissioners, the black small-headed microphone is the one here within the session, and it does the recording, and it does this great job. And then the old-timey looking one is for our public folks, and those are not nearly as sensitive, apparently. And so we regularly, and for our newer members, we regularly get complaints from the public that they can't hear us when they are watching the stream or later viewing it. So we want to be heard on what we have to say. So when you're making your comments, maybe let's focus on the public, old-timey looking microphones and be sure that we're speaking loudly, clearly, and into those. We have two new members. One of them has not arrived yet. That is former House Appropriations Staff Director Joanne Lesnoff. We're very happy to have her join us, and in particular, since he is here, we have our Foundation Executive, Tony Carvajal, has joined us. So, Tony, welcome. Glad to have you. Be a great addition to our commission, and we, of course, still have Commissioner Richter and Commissioner Meggs are recent additions as well. So the elbow room has gotten a little less up here, so maybe the commissioners will be less animated when we speak to you during the course of the day. Okay, do we have an approval of our minutes from the last meeting of October 19?
Move to approve.
Second.
We have a motion and a second. Any discussion? Seeing none, all in favor please say aye. Aye. Any opposed, nay. Motion carries. We will proceed now to our first item of business, and incidentally, we got a lot of business today, so let's keep that in mind as we proceed. So, under Section 4 of item number 4 of our public agenda, consideration of final action, recommended order. The case is Cheryl Thomas Hughes, 2017-088. We have before us the recommended order of the administrative law judge for the Division of Administrative Hearings in complaint number 2017-88 in re Cheryl Thomas Hughes. This is a statutorily mandated complaint to determine whether the respondent's failure to file financial disclosures was willful. The administrative law judge found as a factual matter that the failure was willful, but also determined that the commission had no jurisdiction to prosecute and recommended that the case be dismissed. The advocate, as you know, has filed written exceptions. The respondent did not file any exceptions, nor did she respond to the advocate's exceptions. We have copies of the exceptions and the record and a draft final order recommended by our staff. The respondent and the advocate will be given 15 minutes each for argument and rebuttal. The advocate will argue her exceptions first, then the respondent will reply. The advocate will have time for rebuttal if she so requests, and then we will hear from the staff on the draft order. Commission members are free to ask any questions at any time. Under the Administrative Procedures Act, we are unable to reject or modify a finding of fact from the ALJ unless we determine that there is no competent substantial evidence to support the finding. And if we reject or modify a conclusion of law, we must find that our substituted conclusion of law is as reasonable or more reasonable than the judge's. All right, I see we have Ms. Hadley, so we'll ask that the parties or their counsel please identify themselves for the record. Ms. Hadley?
Respondent violated Section 112.3145 8C by willfully failing to file her CE Form 1 Statement of Financial Interest for the year 2015. Evidence of the elements of this violation are present in the findings of fact that are located in the recommended order. However, we are here with exceptions because the administrative law judge used information not in evidence to recommend that the commission dismiss her case by declaring it did not have jurisdiction to pursue this issue against the respondent. I believe there is a sympathy factor in the recommended order. The purpose of filing a financial disclosure form is to allow citizens to monitor their public officials and employees for any conflicts of interest which may arise. The state of Florida enacted laws to ensure the timely filing of this form. The purpose is defeated if filers are allowed to file this form at will. Respondent's disclosure form for the year 2015 was originally due on July 1st, 2016. She had a grace period to file until September 1st, 2016. After the receipt of numerous notices to file, she did not file her disclosure form by either date. She did not file her form until almost 1 year later, on August 31st, 2017, which is after the Commission's order to investigate was issued. It is imperative that we have an accurate record in this case, not only for the truth, but also in the event that there are any appellate proceedings. To achieve this goal, I filed 6 exceptions. 3 involve paragraphs located in the findings of fact, 2 exceptions are located in the conclusions of law, and 1 is regarding the ultimate recommendation penalty. This commission may reject or modify the findings of fact if it reviews the entire record and determines that the findings were not based upon competent substantial evidence, or that the proceedings on which the findings were based did not comply with the essential requirements of the law. Exceptions 1 through 3. Under these exceptions, as indicated in my written pleading, I request that the Commission strike the portion of paragraphs 1 through 3 that are not supported by competent substantial evidence. The administrative law judge used information that was not in the record regarding those issues. Regarding the next 2 exceptions, the Commission has substantive jurisdiction and can reject or modify a conclusion of law. In exception 4, in seeking to validate his contention that the Commission did not have jurisdiction to pursue respondent under this section, the ALJ used a tortured interpretation of the statute, which is unnecessary as we have the plain language in view. Statutory construction provides that when the words of a statute are free from any ambiguity, the letter of the law is not to be disregarded under the pretext of its spirit. If, as the administrative law judge suggests, the statute is subject to varying interpretations, and that statute has been interpreted by the executive agency, which is the Commission here, charged with enforcing the statute, the deferential principle of statutory construction applies. An agency's interpretation of the statute that is charged with enforcing is entitled to great deference. To be consistent with the Commission's statutory interpretation, this exception requests the deletion of the following paragraphs: 14, 19, 20, 22, 24, 25, 28, 32, 33, 34, and 35. And also with paragraph 27, asking that that be stricken in part. Exception 5. Under this exception, I request that the Commission strike and amend paragraph 18. In this case, the definition used by the administrative law judge for willful is inappropriate for a general intent statute and contrary to the Commission's standard established for willful in the Joel Davis and Kashamba Miller Anderson cases. In the final order and public reports in those cases, the Commission adopted a willful definition which is gross indifference and reckless disregard to the requirements of the law. In exception 6, as stated earlier, the elements to prove a violation of section 112.31458C are all found to be present in the findings of fact and or the conclusions of law. The elements in the relevant paragraph numbers are as follows. 1, First element, respondent must be a current public employee. That element was proven in the finding of fact 1. Second element, respondent must have failed or refused to file an annual statement of financial interest. That element was proven by the finding of fact 11. Respondent must have received notice from the commission regarding the failure to file for the corresponding year. That element was proven as shown in findings of fact 3, 6, 7, also in the conclusion of law 17. Next element, the maximum automatic fine authorized for failing to file must have accrued. That element was proven by finding of fact 8. Lastly, respondent's failure to file is willful. That element was proven by findings of fact 5, 11, and in conclusion of law 18. This administrative law judge found that she willfully failed to file. As stated earlier, he just used that tortured explanation to come up with almost a way to let the respondent remain employed, because I believe, as I stated earlier, there was a sympathy factor. The evidence conclusively proves that the respondent violated Section 112.31458C Florida statutes. I respectfully request that the commission enter the following relief. Adopt the above amended or stricken findings of fact. Find that the amended conclusions of law are as or more reasonable than those found in the recommended order. Find that the definition of willful proposed by me is as or more reasonable than found in the recommended order, and enter a final order and public report consistent with the above exceptions, and recommend removal from employment for respondent's violation of the statute 112.31458C. Thank you.
Wish to reserve your remaining time, or I'm not sure that we have anyone here from the respondent, but we'll see in just a moment. Okay. Any questions for our advocate? All right, seeing none. Ms. Fulford, do we have anyone here from the respondent, on behalf of the respondent? I didn't think so. Okay. Anything else you wish to offer, Ms. Hadley? We have a question from Commissioner Brady.
Just to make sure I understand, this was the order where the administrative law judge basically said, well, if they ever submitted a disclosure, that was fine. There wasn't any real time limits on them submitting disclosures. Or am I misunderstanding that?
I believe we may have heard that with a different case before, but essentially in this one, it appears that he believed that if it was filed prior to the order finding probable cause, then it would be okay.
Okay, thank you.
Or even he said before the commission investigated, it would be okay, which did not occur here.
Any other questions for Ms. Hadley? All right, I believe we will hear from our General Counsel briefly on the matter.
Thank you, Chair Norris. I appreciate it. Basically, the point I'd like to make to you is what you already have in the memorandum and the draft final order and public report that I had prepared and has been in your materials. And what it does is basically accepts what's important or takes in and adopts what's important in the advocate's exceptions. There are a couple of her exceptions that the draft final order rejects, but I don't believe those are material to what you really need to get done here in view of how the legal staff sees the statute and what you've done before and what various ALJs have done over there contrary to this ALJ. But in essence, my view is that what you have here with the recommended order of the administrative law judge is a real detailed, almost attempted rewrite of the statute that would go against the reasonable intent of financial disclosure, which is to file and to file timely and have that information out there in front of the public. And these different periods that the ALJ refers to in the recommended order, you don't see any of that stuff in the statute. When you look at the financial disclosure statute 112.3145 as a whole, it is apparent that this timely filing is required and that the penalties for willfully failure to file are geared to that. So, and there is also language in the draft final order that complies with the statute in terms of what you need to do when you're accepting an exception and you're doing something in relation to a recommended order, and I think it's all set out there adequately. I think it maybe is not phrased exactly as the advocate would phrase it, but the substance of this draft final order, I think, gets to where she wants to go. And I don't have a partisan view of this thing. I'm just trying to make this usable for you in a workable sense as your counsel. And I think that what you have here in front of you with this draft order, if you adopt it, I think you'll be doing the right thing here in a legal sense. And if you have any further questions of me in particular, I'll be happy to try to answer them.
Any questions for counsel? Got a quiet group this morning. All right.
If I might, Mr. Chairman, just
Yes.
one more thing. Thank you, sir.
Please.
I think what's important here is that the administrative law judge, one of the things that's important is he did find as a finding of fact that the respondent's failure to file was in fact willful. And it's, I think, appropriate to recognize the significance of that, because under Chapter 120, one of the things you can rarely do is disturb a finding of fact that's made by an administrative law judge. The commission has broader latitude to deal with legal construction of the statute and interpretation of the statute. But here we have that very important factual finding that no matter what standard you use, either what I believe to be the correct standard or what I believe to be the erroneous standard that the administrative law judge talks about, whatever legal standard is used, factually speaking, sitting as a jury of one, a bench trial, so to speak, the administrative law judge did find that this is a willful failure to file. And I think that's crucial, very crucial. And you don't have to change any findings of fact to get to where you need to get, I think, in this situation.
Thank you, Mr. Anderson. Last call for questions from Mr. Anderson. Commissioner Meggs.
And I don't know who this question would go to, but in my reading of this, was she not given, or this respondent not given numerous opportunities before any action was taken to correct the situation?
Through the chair.
Yes.
If I might, I believe the administrative law judge so found that, and I think his language was to the effect of the respondent was showered with notices of her need to file and her lateness.
Anything else from Mr. Anderson? Any questions for Mr. Anderson? All right, we will proceed to the deliberations. Commissioners and our newer commissioners, this is where we really earn our travel reimbursement in cases like this, where we have a matter that comes back from the Division of Administrative Hearings, because it's a more complex process as to what the commission's analysis is. I'll briefly review that again for you. The commission must vote on the exceptions and must vote on whether to accept the findings and conclusions submitted by the ALJ and whether any changes should be made. If any changes are made, the reasons must meet the announced criteria and should be explained by the member who wants to make the changes. The motion can encompass all of the recommended order, or it can break down the order into findings of fact, conclusions of law, and penalty. The commission can handle all of this by adopting the staff's draft final order, which addresses all exceptions, findings, and conclusions, or we may do something different accordingly. Is there a motion?
I move to approve the draft final order and public report.
We have a motion. Is there a second?
Second.
Commissioner Berger with the second. Any discussion? Seeing none, we'll proceed to the vote. All in favor, please say aye. Aye. Any opposed? Motion carries. All right, item 5A on our agenda today, consideration of final action stipulations. First is N. Ray Shane Crawford. This is consolidated complaint numbers 2016-72, 2017-79, and 2017-17. So will the parties or their counsel please identify themselves for the record? On behalf of the respondent.
Good morning, Your Honors. My name is Linda Vaughn Edwards, and I am here on behalf of the respondent, Shane Crawford.
Welcome. Ms. Hadley?
Are you ready?
For the record, please.
Melody Hadley, Commission Advocate.
All right, we have before us a stipulation between the commission advocate and the respondent. The commission may vote to approve or reject the stipulation. This is not a pre-probable cause stipulation, so if the stipulation is rejected, the matter will be heard at the Division of Administrative Hearings, or the parties can attempt to arrive at a new stipulation. Complainants have the right to comment in writing on proposed stipulations. We have received a comment from 2 of the complainants. It was emailed to you on November 30 and is again being handed out now by Ms. Fulford. So we'll give you just a moment to do so, please, Ms. Fulford. Trying to be paperless. Yeah, it's not working out. Okay. Yes, all right, Ms. Hadley, please proceed.
Respondent served as the city manager of Madeira Beach. There were 8 allegations in the order finding probable cause. As you've read in the joint stipulation, the parties have come to an agreement to request the dismissal of allegations 1, 2, 4, 5, and 8. We ask that the commission accept respondent's admission that he violated sections 112.3137 and 112.31484, which are allegations 3, 6, and 7. In the stipulation, the respondent admitted that he violated the ethics law and agrees to the entry of a final order recommending a civil penalty of $2,000. We respectfully ask for the commission's approval of the joint stipulation.
Any questions from the members? Ms. Edwards, anything you would like to add?
The respondent agrees with the stipulation and asks approval by the commission.
Thank you. Any questions from Ms. Edwards? All right, seeing none, we will proceed with the motion. Is there a motion on adoption of the stipulation?
Move to approve the joint stipulation.
Commissioner Zanka moves. Any second?
Second.
Commissioner Meggs? All right, second by Commissioner Meggs. Any discussion?
In each allegation, the maximum fine could be $10,000.
Commissioner Brady?
Yeah, though I read this last week and just reviewed it again, what I remember of the investigation discussion at the time was that the respondent really was kind of a serial violator, that he moved through several of these agreements with people in terms of receiving gifts for rental apartments that were significantly below what we believe to be the actual value, and feel there is some degree of truth in the matter of the fine being relatively minor.
Mr. Zanka?
I recall this case very well because I was of the opinion at the time there was insufficient evidence of what the rental value should have been because they had been left vacant for a while and one had never been rented. I don't find these to be substantially low. I think this is, I actually voted against probable cause, I think, in all of them. And so I think this is fair as opposed to going to DOA where we may not get anything.
Any other discussion? Commissioner Berger.
And I'm looking at the letter that Commissioner asked the question about. I guess what the complainant is saying is that the resolution is too low, and just listen to what Commissioner Zenka has to say. But I'm guessing, and maybe you can answer this question, that this was a best interest negotiation amongst the parties based on the facts presented.
After discussion and after listening to legal arguments on both sides, and we still had some words back and forth, this was in the best interest of this case in the state of Florida.
Any other discussion? Seeing none, we'll proceed to vote. Call the question. All in favor, please say aye. Aye. Any opposed, nay. Motion carries. Thank you very much. Thank you, Ms. Edwards. Have a good day. Okay, we will proceed to 5B. In re Ricky Thompson, again, consolidated complaints, number 2016-113 and 2017-16. We ask that the counsel for the parties please identify themselves for the record. Respondent.
Good morning, ladies and gentlemen. John Whitaker for Ricky Thompson.
Welcome, Mr. Whitaker.
Thank you.
Melody Hadley, Commission Advocate.
All right, Commissioners, I will not, same matter, same type of matter. We have it's not a pre-probable cause stipulation, so if the stipulation is rejected, the matter goes to DOA, or the parties can attempt to come up with a new stipulation. We did not receive any comment from the complainants with respect to this stipulation. Madam Advocate, please proceed.
Respondent serves as the Stark City Clerk. He admits the facts as set forth in the report of investigation related to authorizing the use of city funds to pay for an employee's legal fees without obtaining proper approval. Those fees were returned. And also the general interference with another official's supervision of that same employee. In the stipulation, respondent admits to violating the ethics law and agrees to the entry of an order recommending a civil penalty of $1,000 with public censure and reprimand. We respectfully ask for the Commission's approval of the joint stipulation.
Anything from the respondent?
Your Honor, that is correct. Your Honor, members of the Commission, that is correct. We are asking the Court to accept the stipulation. Mr. Thompson has thought about this for quite some period of time. It's taken, unfortunately, a profound impact on his health, and he hopes the Commission will let him move forward with this agreement. Thank you.
Thank you, Mr. Whitaker. Any questions for the counsel from the Commission? Seeing none, do we have a motion?
Move to adopt.
Commissioner Brady moves. Is there a second?
Second.
Commissioner Zenka seconds. Any discussion? Going once, going twice. Okay, no discussion. We'll call question. All in favor, please say aye.
Aye.
Any opposed? Nay? I believe the ayes have it, and we will move to number C. Thank you, Mr. Whitaker. Have a good day. Item C, 5C, this is consideration of final action on a stipulation. In re Jerry L. Stambaugh, complaint number 2017-50. Do we have appearances on behalf of the respondent?
Mark Aaron on behalf of Jerry Stambaugh.
Welcome, Mr. Herron.
Melody Hadley, Commission Advocate.
Thank you, Ms. Hadley. Again, Commissioners, same approach here, same procedures. Ms. Hadley, please proceed.
Respondent serves as a member of the Auburndale Planning Commission. There were 3 allegations in the order finding probable cause: 2 voting conflicts and a misuse of position. We ask that the Commission accept respondent's admissions that he violated sections 112, 31433, and 4, and that he failed to properly disclose his conflict after he abstained from voting on a 2016 matter. In light of the respondent's admissions and the fact that he abstained from voting, I recommend that the allegation that he violated or he misused his position be dismissed. In the stipulation, respondent admits he violated the ethics law and agrees to the entry of a final order recommending a civil penalty of $2,000 with public censure and reprimand. We respectfully ask for the Commission's approval of the joint stipulation, including the dismissal of the misuse allegation.
Any questions from Ms. Hadley? Seeing none, Mr. Herron.
Mr. Chairman, members of the commission, we ask that you adopt the joint stipulation in recognition of the admissions and the facts of the case. Thank you.
Thank you. Any questions from Mr. Herron? Seeing none, we'll proceed for a motion. Is there a motion?
Motion to approve the amended joint stipulation.
Second? We have a motion and a second. Any discussion? Seeing none. Call the question. All in favor of the motion, please say aye. Aye. Any opposed, nay. Motion carries. Thank you, counsel. All right, we will move to item 6. This is an informal final hearing on a complaint in re Marcos Villanueva. Hope I did that correctly. Complaint number 2017-55. So the matter before us, commissioners, is for a final hearing because it appears and has been acknowledged by the parties that there are no disputed facts. The case was set for hearing at the Division of Administrative Hearings and was returned to us because there appeared to be no disputed issue of material fact. We have copies of the file in this matter, including the joint pre-hearing stipulation entered into by the parties during the course of the proceedings at DOA. So will the parties please identify themselves for the record? Our respondent.
Good morning. Jose T. Herrera on behalf of Marcos Villanueva.
Thank you, Mr. Herrera. Welcome.
Melody Hadley, Commission Advocate.
Thank you, Ms. Hadley. Commissioners, this hearing will be conducted pursuant to sections 120.569 and 120.57, subparagraph 2 of the Florida statutes, and Florida Administrative Code Rule 28106. At this hearing, we will determine whether there is a violation based upon the facts, and if we find a violation, recommend a penalty. Both parties will have an opportunity to make presentations to the Commission, but if a dispute of material fact is asserted during the hearing, we will then refer the matter back to DOA. Each party will be given 15 minutes, starting with the advocate, and the advocate may reserve time for rebuttal. The commissioners, of course, may raise questions at any time during the proceeding. Mr. Herrera, if you want to step back and have a seat we won't make you stand there for 15 minutes. Ms. Hadley, if you're ready, please proceed.
I would like to request that my remaining time be reserved for rebuttal.
Yes, ma'am.
As shown in my written motion to render final order, the evidence reflects that respondent violated section 112.31453 by his failure to check a box to indicate whether he was using comparative or dollar value thresholds as his method for calculating reportable interest on his 2016 disclosure forms. He did it neither on his original form nor on his amended form, where the instructions clearly state to check a box. As a matter of fact, respondent has admitted to this failure. Under section 112.31453, a person filing a statement of financial interest shall indicate on the statement whether he or she is using the method specified in paragraph A or B as follows. Paragraph A says if you're going to use comparative percentage, you check that box. Paragraph B says if you're using dollar value reporting, you check that box. With the issuance of the order to investigate in respondent's case, the Commission on Ethics determined that if it were true that respondent failed to indicate how he was going to report his interest, then it is not de minimis, as it could constitute a failure to meaningfully disclose income, assets, and liabilities. Here's why it's important to disclose meaningfully. Citizens of the state of Florida have a right to receive unencumbered information from its officials on the front end. On the back end, citizens who file complaints are subject to attorney's fees. If, for instance, a citizen is aware of or was aware of an $11,000 loan, depending on a filer's method of reporting his interest, that loan may or may not be reportable. A citizen, one, could not file out of fear or 2, file and it turned out to be a liability that did not meet the threshold for reporting. Either way, this issue could be alleviated with a simple check of a box. In my motion to render a final order, I'm requesting that the Commission ratify and adopt the ALJ's August 6, the Administrative Law Judge's August 6, 2018, order closing file and relinquishing jurisdiction. I'm asking that the Commission find a violation of Section 112.3145 Florida statutes, and that the Commission enter a final order recommending public censure and reprimand and a civil penalty of $1,000 for respondents' violation of 112.3145 of Florida statutes. Thank you.
Any questions for the advocate? All right, see, oh, we do have one? I'm sorry, Commissioner Berger, I turned away too quickly. Go right ahead.
You stated that the respondent did not check the box on the original and then again on the amended form.
Yes.
Was there a reason why that you received on the amended form why the box was not checked?
I'm not sure. I believe he gave an explanation in his report of investigation about why he did not check the box. I don't know if it'd be better for them to explain versus me trying to explain why he did not do it. I do know that it's clearly stated on the instructions, in pursuant to the law, it says you are supposed to check a box.
And it's not optional for people to move on the form?
The law states it, and then the instructions following the law stated in big letters on the form that you're supposed to check a box.
Any other questions? Commissioner Rick?
Thank you. On the amended form, were there many or material changes on that form? And was the intent of the intended form to change the content of the form? Or did it appear, because it made the same mistake twice, which would indicate to me that it may have been inadvertent.
As stated, the instructions say you must check the box, and then to get another form, and again, it states you must check the box. It looks like the only change that was made on the amended form, there was an inclusion of income. That was a change on the amended form. But regarding the instructions remain the same on the original and the amended form, that you must check a box regarding how you're going to report your interests.
So he was motivated to file a change because of the information that he was reporting. He wasn't motivated to file that change because of his awareness of the box not checked.
I will have to make a guess about his motivation. So, I'm not sure.
Any other questions for the advocate? Commissioner Berger?
One more question. When the box is not checked, are you all able to verify the accuracy of the form that's been submitted?
No, because depending on which box you check, that has to do with every disclosure you make for every other section on that form. Depending on if you use dollar value, for instance, and I believe this was a Form 1, then if anything, if there's an asset, if there's income or if there is a liability that's exceeds $10,000, you have to report it. If you use percentage, there's a different calculation that you have to use. So some things you may have to report under dollar value, you don't have to report under percentage, and vice versa. So if he doesn't check the correct box, we may not be able to verify the accuracy of the form or the information that may subsequently come out about what should have been disclosed.
Any other questions for the advocate? All right, respondent, Mr. Herrera, welcome. Please proceed. You have 15 minutes.
Thank you. And I think I can clarify some of the questions that I heard. So the first thing that the commission needs to find is that the omission was material. There is no materiality. There hasn't been any materiality shown. He simply negated to check a box. Mr. Villanueva is a former Sweetwater Police Lieutenant and retired to run for commissioner in the city of Sweetwater. He filed it as a candidate. The check, he missed it, he made a mistake, and that was the end of it. There was a subsequent lawsuit filed in Miami-Dade County Circuit Court making these same allegations in front of Circuit Court Barbara Arezes. Judge Arezes dismissed it saying...
Objection, this information is not in the record.
It's important because Ms. Hadley knew about this. This was provided to Ms. Hadley.
Well, thank you, Mr. Herrera, but I would, under the rules of the commission, we are confined to the matters that are in the record. So I don't want to interrupt your presentation, but I ask that you do try to confine it to the matters that are in the record, and if it's not in the record, please let the commission know that so that they're not confused.
So the lawsuit is not part of this record, just to be clear, but these issues were ferreted out in front of a circuit court judge.
And let's try to focus on the record before the commission.
Simply put... Sure, sorry.
I'm having a bit of trouble hearing you as well, please, Mr. Herrera.
So this is, the violation here is de minimis. What Ms. Hadley is asking for is, I believe, excessive in light of the de minimis nature of it. The idea of financial disclosure is to appraise the public of any potential financial conflicts with any elected official or public official. The fact that he is a retired police officer, it's a public salary, and he doesn't have to disclose a public salary, that's within the statute, appraises the public of any potential financial conflicts he may have as a sitting commissioner in the city of Sweetwater. And it's as simple as that. If you fail to check a box or you make full disclosure, you've appraised the general public of the fact that there is no conflict or there is a potential conflict. In this case, there wouldn't be because he was a former law enforcement officer. And again, there is no materiality here. There wasn't a material omission on the financial disclosure. If the commission has any questions.
Okay, we have some questions from the commission. Our vice chair, Commissioner Rosenka.
Did he file a subsequent amended form to check the box? Did he ever file a subsequent one?
He filed this year's, which is not part of the record, but this year's he correctly filed it with the box check.
But not for 2016?
Not for 2016.
Any other questions? Commissioner Richter, we'll start at the far end and come this way.
You know, what motivated him to file the amended form?
Unfortunately, it's not part of this record, but it was done as part of that litigation. The person that filed this complaint, the complainant, was the same attorney that handled that matter in front of the judge, and the complaint was politically motivated. And he forgot to check the box. He filed it. He just put that he was a retired law enforcement officer from the city of Sweetwater.
So he was motivated by the complaint.
You could say that he was motivated by it, but he didn't have to disclose his public salary as a law enforcement officer because he doesn't have to disclose it per the statute.
Commissioner Brady.
So if I look at the initial Form 1, he indicates that he has no income. And when I look at the revised one, it doesn't check either box, but at that point, he reports his income from the Sweetwater Police Department.
He's a retired police officer, and the statute doesn't require if you're a government official or a public official to disclose your income. It's a matter of public record already. Under Chapter 119, anybody here can pick up the phone and call Sweetwater and ask for his entire payroll record, and there is no secret.
But in the subsequent form, he did disclose.
He just simply put, I'm a retired Sweetwater police officer.
Any other questions? Commissioner Carvajal.
I understand what you just explained, but did he ever explain to you why he did not check the box on the second form?
He never gave me an explanation. It just seemed that it's always been I guess he overlooked it. He just filed it. He had nothing to report. He simply put that and filed it, and he didn't feel he was hiding anything, and he wasn't hiding anything.
Any other questions? Commissioner McManus, yes, please.
Are you arguing that it's not important to check the box so we know whether we're using the comparative percentage or the dollar value? You think that's not substantive?
I'm suggesting that in this case, it's de minimis. I'm not suggesting,
The whole form cannot be accurately understood unless you know which method of reporting is being used. And you think that's de minimis?
I think in light of the fact that he's a public official and he's exempt from disclosing in his case, I think it's de minimis in his case. I don't think there's any materiality, and in fact, there hasn't been any materiality shown that he intentionally concealed anything, not even a document produced by Ms. Hadley or the advocate that shows that he materially concealed anything. And I think that's the first step. You have to show that it was material.
Any other questions? Commissioner Richter.
So I'm looking at the amended form. Part H, explanation of changes, indicates clerical error as to oath of participant or retirement. So would that be why he filed the amended?
He filed it to put that he was a retired law enforcement officer. He had retired before he ran for office. So he was retired and he had no income to report other than the income he was receiving or from the City of Sweetwater Police Department.
Would this disclosure indicate something significantly different if he had checked either one of the boxes? Would that give the reader of this disclosure or somebody interested in reviewing it, provide them any different information whatsoever if one or both boxes?
No, in fact, if you go back and you verify everything at the time that he filed it, regardless of which box you checked, he wouldn't have had to disclose anything.
Any other questions, commissioners? The chair has one. So, Mr. Herrera, which method did he use in his filing from 2016? Was it the comparative or was it the dollar value?
Mr. Chair, it would be irrelevant which one he used because he wouldn't have had to report either or, because his liabilities wouldn't qualify for reporting, whether he checked the percentage or the dollar value. That's important.
The question is which one did he use? The law is pretty clear. You have to use one or the other methods, right? And so the question is which one did he use? Is your answer you don't know?
I couldn't tell you one way or another.
How then is the staff and the public to know?
Here's the important issue, which is he's a public official. His salary and everything is public. So either way, wouldn't have had to, anything, whether he checked the box one way or another, he wouldn't have had to report anything. It's all public record. It's all made public. Anybody can go and see it. And in fact, it's in the statute. It says that a public official running for office and filling one of these out does not need to disclose his public salary. And in fact, the onus is on Ms. Hadley and the advocate to show a material violation. They haven't presented a shred of evidence that shows that he omitted anything intentionally, and by virtue of checking the box, it would have been omitted. They haven't presented anything, and unfortunately, there's things that aren't part of this record, and I'm confining myself to the record.
Well, let me ask a couple other questions. Is his name material?
I believe his name, to identify who filed it.
What other portions of the form do you consider to be not material?
I think a clerical error is different than a material omission. For instance, concealing an asset, concealing a financial liability to somebody who does business in front of a elected body. That's not the case here. It's very different. made a simple clerical error, and that was it. In fact, he came back and he put that he was a retired police officer, which he didn't have to do. The statute says he doesn't have to do that.
Commissioner Richter.
Not to belabor it. So do I correctly understand, I do understand that he did not check the box. The bad, sure he regrets it. Had either one of those boxes been checked, would any of the information in the report be correct or incorrect?
Your objection, there's no evidence in the record to be able to support that answer.
I didn't hear what you just said.
There's no evidence in the record to be able to support being able to answer that question.
Please proceed, Mr. Herrera.
I can only answer that, if I may answer your question, I can only answer that question based on personal knowledge, and the fact is that whether you do the dollar amount or the percentage amount, he wouldn't have had to report anything.
Yes, Commissioner, please proceed.
Thank you so much for the question. Just so that I'm clear, he has never filed an amended report with the box checked for 2016 ever yet.
No, he has not, and my understanding was, I don't believe he was given an opportunity before.
Has he ever received a notice from the commission to file an amended notice with the checked?
That is something that from my understanding, he was never given that opportunity. And if I'm stand corrected, Ms. Hadley can correct me, my understanding is he was never given that opportunity.
Madam Executive Director.
We don't send people notices that they should correct their forms or deprive them of opportunities to do so. People can file as many amended forms as they like, but we don't specifically ask that they do so.
May I clarify my question, Chair?
Please.
Has he ever been notified that there was a deficiency on the form?
My understanding is the first time he learned of the deficiency was his complaint.
And just one more question, Mr. Herrera. Wasn't the deficiency evident on the face of the form that he filed?
And I think he already answered that when he answered the questions, which was it was overlooked at that time. It wasn't intentional, and I think that's the important part here, Mr. Chairman. It's the intent.
Any other questions for Mr. Herrera? All right, thank you, sir.
Thank you.
Ms. Hadley, I think you have a few minutes left here on rebuttal, if you wish.
I just want to clear up a few items. I heard that Ms. Hadley is asking him to check the boxes. Actually, the legislature said to check the box. It's in the law. It says to check the box to provide this information. And regarding Mr. Villanueva had the opportunity to amend. He amended one time. Nobody stopped him from he amended his form one time, so he could have amended again. It clearly states that he's supposed to check the box. In addition, intent is not an element to a violation of this particular law. Material is not an element to this particular law. By Mr. Villanueva not checking the box, again, every response on that form is dictated by which box he checked. We don't know, and we don't have any information to verify what would have been an income, what would have been a liability, what would have been real property. We needed that box checked to be able to verify any further information. If you have any questions, please let me know.
Any further questions for the advocate?
There's been questions about motive. Is motive an element?
No.
Any other questions for the advocate? Thank you, Ms. Hadley. All right, commissioners, do we have a motion? Commissioner Rosanka,
Well, I'm going to start with a preface before I do my motion.
you have the floor.
I would feel better and might see this differently if he had filed another amended complaint and checked the box. But under 112-3145-10C, for the purposes of this section, an error or omission is immaterial, inconsequential, or de minimis if the original filing provided sufficient information to the public to identify potential conflicts of interest. I don't think there is sufficient information in this Form 1 or the amended one because a box wasn't checked. As Ms. Hadley stated, you can't tell what he included or didn't include. I use the comparative method, which would be way different than the dollar threshold when I do my Form 1s. So I know the difference. Also, too, under the 112-324-11, a de minimis violation doesn't apply to this particular section of the code. So with that, I'm going to move to find that this proceeding is appropriate according to section 120.572, that we adopt and ratify the ALJ's August 6, 2018 order closing file and relinquishing jurisdiction, that there is a violation of 112-3145, that I'm going to recommend a civil penalty of $500.
Okay. Commissioner Berger.
I just have a question, I guess, for the chair of the council. And I do agree with what Commissioner Rosenka said, but are we allowed to recommend the penalty in this type of proceeding?
Through the chair, yes.
I would second that.
We have a motion and a second. So the motion is to accept the advocate's recommendation with the exception of lowering, I believe it is the fine to $500, the penalty to $500. Is there any discussion on the motion before the commission? Commissioner Brady.
When you look at the first financial disclosure Form 1, which is the form we fill out, to the best of my knowledge on this form, there is no place that it requires us to give a specific dollar amount. It is only a place to identify where our income comes from. So when we look at the first form, he simply said, oh, I don't have any income anywhere. Didn't check the box. Everything is marked NA. In the second form, again, there is no identification of how much money he made as a police officer. But what his basically statement is that, oh, yeah, I worked for the Sweetwater Police Department without identifying any set of sums one way or the other. And again, in both cases, the box is not checked. I, at some level, feel a little foolish about fining somebody for not checking a box twice, but I think the motion made by Commissioner Rosenka is fair and appropriate.
Any further discussion?
Is it public censure and reprimand in the civil penalty of $500?
I just said civil penalty. If someone wanted to add that, I would consider an amendment, but I think I missed that part.
I would move to amend the motion to include the public reprimand.
Okay.
I'd accept that amendment, or do we have to vote on the amendment?
Well, I think, yes, I guess that we could have a motion for an amendment, and that would need a second, and then we vote as to whether or not we amend. Look to the executive director for our Robert's Rules.
There are no
Since we don't do Robert's Rules of Order.
Guys' rules.
If the maker of the motion and the seconder of the motion are amenable to the amendment of the motion and so state, I think that clarifies it for everyone.
Yeah, who cares what Robert thinks anyway? Right, so.
We both agree.
Okay, so we'll go by Guy's rules, and Guy agrees with the executive director. And so we have our motioner and seconder agree to the amendment. So the amendment, again, as I think was stated, was to accept all aspects of the advocate's recommendations. That's how I actually understood the motion, so I apologize if I missed it. Except reducing the civil penalty of $1,000 to $500. That is the pending motion. Any further discussion on that pending motion as we have clarified? Seeing none, we'll call the question. All in favor, please say aye. Aye. Any opposed? Say nay. There is no. Motion carries. Thank you, Mr. Herrera. right, Commissioners, we will proceed to item 7. This is consideration of advisory opinions. We only have 4 advisory opinions on our agenda today. So the first one is file number 2725, gift acceptance and disclosure, conflict of interest, County Economic Development Director's participation in economic development events funded by local economic development corporation in good old Charlotte County. Mr. Anderson, I believe you're up for this matter.
Thank you, Chair Norris. This is pretty straightforward. You know, what the gift law is all about is undue influence and that sort of thing. And here you really have an economic development director in the heart of economic development, somewhat subsidized by an economic development corporation of historical economic development purposes, not just something created at the last minute. The legal analysis is in the draft opinion, but in essence, it is something that probably needs to come before you because it's the sort of thing that the public is interested in, but legally it does not appear to be a problem under the law, and therefore the draft is offered for your consideration. If you have any questions, I'll attempt to answer them.
Any questions for our General Counsel? Commissioner Brady, you're up.
So the private nonprofit economic development corporation has no preferences in terms of economic development, no favorites, no nothing. It's simply, yeah, it's important these guys go to meeting, and since the city doesn't think it's important enough to pay them to do it, that it's okay for somebody else to pay them to do it.
Well, through the chair, I wouldn't know exactly about their motivations. I know certainly that there can be priorities in terms of economic development or priorities about whether or not we ought to have certain development at all. Yes, sir. It just seemed like that this had been occurring, and it seemed to be a hand-in-glove relationship, and there was no indication that there was anything frictional in this particular scenario. This is not to say that going forward, every situation like this in every locality would necessarily be legitimate. These things are always on a case-by-case basis. They do provide some, for lack of a better term, precedential effect, but you're not giving carte blanche to the world to do this everywhere in every situation if you adopt this draft.
Any other questions for Mr. Anderson? All right, Commissioners. So, I will. Thank you, Mr. Zanka. We have our new commissioner, Ms. Lesnoff, has now, I guess we'll let the record reflect, has joined. We would ask that she not take up any matters until the next one, since she came in during the middle of this one, but welcome. We're glad to have you. So, sticking with the orders of business, we have before us this advisory opinion drafted by counsel. If there are any other questions for counsel, let's hear them, and otherwise we'll accept a motion. Commissioner McManus moves. Any second?
Second.
Second from Commissioner Rosanka. Any discussion, members? Seeing none, we'll call the question. All in favor of the advisory opinion as drafted, please say aye.
Aye.
Any opposed, nay? The opinion is adopted by the commission. All right. We will now proceed to file number 2726. This is a conflict of interest matter. Company owned by civil council member doing business with community redevelopment agency in Sebring. I do not believe we have anyone here on behalf of the requester. Is that correct, Ms. Fulford? Thank you. Ms. Klenke, I think, is up for our advisory opinion here.
That's correct. Caroline Klenke from Commission Legal Staff. File number 2726 arises from a question from the Sebring City Attorney posed to him by a member of the City Council. Recently, the Sebring Community Redevelopment Agency has sought to switch its advertising mechanisms from static billboards to electronic billboards to enable it to change its messaging throughout the course of the year. In evaluating digital billboard location options, the CRA board has sought to select billboards based upon their location in proximity to their current static billboards and along major thoroughfares in Sebring, closest in proximity to the downtown district where their activities occur. Based upon this criteria, the board selected 3 electronic billboards. All 3 billboards are owned by an advertising company that is owned by a member of the Sebring City Council. As such, this gives rise to a conflicts of interest analysis under 112.313 subsection 3, which prohibits doing business with your own agency. In particular, the second part of this provision prohibits a public officer from acting in a private capacity to sell goods or services to his political subdivision or to his own agency or to an agency of that political subdivision. In previous opinions of this commission, we have found that either owning a material interest in or being a director of a business entity selling goods or services constitutes acting in one's private capacity to sell within the meaning of the second part of the statute. Accordingly, absent the application of an exemption to section 112.313 subsection 3, the second part of the statute would prohibit the requester's company from engaging in a contractual relationship with the CRA to sell services in the form of advertising on the billboards owned by his company, a company which he is the sole owner. However, the provisions of the Code of Ethics also contain a series of exemptions to the conflicts of interest provisions. Staff postulates in the draft opinion before you today that the exemption contained in 112.313(12)E, commonly referred to as the sole source exemption, is applicable in the instant case to negate the conflict of interest. This exemption to the conflicts of interest provisions of both 112.313(3) and 7 serves to obviate a conflict of interest when the official's business is the only source of supply within the political subdivision, or, as here, where the official's business offers a uniquely advantageous or uniquely optimal source of supply to reach a specifically targeted audience. In an analogous opinion issued by this commission in CEO 00-10, which involved another community redevelopment agency, there seeking to purchase television station advertising, in which the business, which was the owner of the local television station, was owned in part, had a material ownership interest by an employee of the CRA themselves. The Commission on Ethics applied the sole source exemption to negate the conflicts of interest, reasoning that while there were other TV stations which could reach at least part of the community redevelopment agency's target audience, those stations addressed a much larger audience and were concomitantly more expensive. As such, the agency had identified the optimal and sole advertising medium uniquely positioned to reach the audience sought. In accordance with CEO 00-10, staff recommends application of the sole source exemption in the instant matter to negate the conflicts of interest and to permit the Sebring CRA to contract with the requester's advertising company to retain the 3 electronic billboards positioned in locations which the CRA board has identified as optimal to reach motorists along Sebring's major thoroughfares and to direct them to the downtown district where the Sebring CRA activities occur. This opinion is submitted for your consideration, and staff is available to answer any questions that you might have.
Commissioners, any questions for Ms. Klenke? great job. You did. All right, seeing none, is there a motion?
Move to adopt the advisory opinion as stated.
Thank you, Commissioner Brady. Is there a second?
Second.
Second from Commissioner Meggs. He just beat you out just by a hair. All right, so we have a motion and a second. Any discussion? Seeing none, all in favor of adoption of the advisory opinion as drafted, please say aye.
Aye.
Aye. Any opposed, nay? Motion carries. Thank you, Ms. Clanky. Okay, next item is file 2727, Anti-Nepotism General Manager, Chief Executive Officer of Municipal Utility Board selecting son of board's chair for position in Monroe County. We have our Ray Schaefer up to bat on this matter. Mr. Schaefer, please
Thank you, Chair. This is a pretty straightforward nepotism issue. Concerns Section 112.3135, which is the Anti-Nepotism Statute. Now, that law prohibits a public official from appointing, employing, promoting, or advancing a relative, or for advocating that that decision be made on behalf of a relative. And it can also be triggered when the collegial body that a public official sits on decides to appoint, employ, promote, or advance one of his or her relatives, even if that official abstains from the decision and doesn't participate. The situation here is that the utility board for the city of Key West is looking to hire someone for a new position as a director of legal and regulatory services. Apparently, an outside consultant told them that that new position would streamline their operations, and so that recommendation was accepted. The question here, though, is that the son of the board's chair has been picked as the applicant best suited for the position, and an employment offer has been extended to him, contingent on your determination as to whether that's going to place the board's chair in violation of the nepotism law. The key fact here, as you can see in the draft, is that neither the board nor the chair personally have been involved in the hiring decision. From what we've been told, the board's general manager had the sole authority to make the hire. She alone participated in posting the job. She reviewed the applications with 3 other individuals, none of whom were board members, and she made the final selection of the chair's son. So neither the board nor the chair participated in that process or made any recommendations about her selection. And this is not the case either where the board has just delegated its hiring authority to the general manager to make this one hire. That could trigger the nepotism law as well. According to the board's charter and bylaws, hiring authority for all board employees, I think except employees in the office of the board's attorney, but that hiring authority is vested in the general manager, not in the board. So because it was the board's general manager alone who made this decision, and because the board and the chair weren't involved in the hiring process and made no recommendations, the draft recommends you find the chair won't be in violation of the Anti-Nepotism Statute if his son is selected. I recommend you adopt the draft opinion. I'm presenting it for your review, and I'm happy to answer your questions. And I will say, too, that Mr. Finkel is here on behalf of the Keys Utility Board, should you have any questions for him.
Any questions for Mr. Schaefer? We have a motion to adopt from Commissioner Richter. Thank you.
Second.
Second from Commissioner Rosanka. Any discussion? Seeing none, all in favor of the advisory opinion as drafted, please say aye.
Aye.
Any opposed, nay?
Nay.
Motion carries. What do we have now? 9? We got 8-1. Okay. All right. Thank you very much. We will move now to file number 2728, post-employment restrictions, former FDOT construction manager employed by FDOT contractor in Bartow, and I believe we have the requester present. Let's see, I believe Ms. Clanky, isn't this you? Yep, you're up to bat, Ms. Clanky, please.
Caroline Clanky, Commission staff. File number 2728 arises from an inquiry from Ben Harris, who is, as the chairman just noted, here with us today. He is a former employee of the Florida Department of Transportation, and after I postulate staff's theory with respect to it and introduce the statutory provisions and how they apply, he would like to make a brief statement. Prior to leaving his public position with the FDOT on October 4th, 2018, Mr. Harris worked as a construction manager in FDOT's 1st District for 15 years. During the period immediately preceding his leaving public employment, FDOT engaged in the process of selecting a firm or contractor for a professional services contract to provide construction engineering and inspection services related to a road widening project transpiring in District 1, nay, transpiring as we speak. The requester was not involved in any capacity in the procurement or development of the FDOT contract with this contractor, or the selection of the contractor in any capacity. Rather, other FDOT personnel selected the contractor, Eisman and Russo, as the consultant involved in the road widening project. However, following FDOT's selection of Eisman and Russo as the FDOT consultant, the FDOT employee spearheading the contract development and procurement process left public employment. Thereafter, on July 11, 2018, FDOT transferred contract oversight authority to one of the 4 employees supervised by Mr. Harris. Shortly thereafter, on October 4th, 2018, Mr. Harris himself left FDOT employment in favor of a private employment opportunity as a construction project manager with Eisman and Russo. In light of his departure, Mr. Harris has inquired with particularity about the post-public employment restrictions contained in Section 112.3185. And that section contains several, however, 2 are germane to this analysis. They are contained in Sections 3 and 4. Section 3 of this provision prohibits Mr. Harris from going to work for a company in connection with a contract where he was personally and substantially involved in the procurement and development of the contract while he was an FDOT employee. Staff recommends in the draft opinion before you that this provision is inapplicable to Mr. Harris in the instant case because the facts indicate that he had no involvement in the development or procurement of the CEI contract formed between FDOT and Eisman and Russo. However, Section 112.31854 contains an additional post-employment restriction which prohibits Mr. Harris for 2 years from the date he left FDOT, October 4th, from working for a company in connection with a contract for contractual services which was within his responsibilities or that of his FDOT subordinates while he was an FDOT employee. The Commission on Ethics has found that the term within his or her responsibilities, as it is used in this section, means monitoring, managing, or having ultimate responsibility or through subordinates for a contract for consulting services, an existing contract. Thus, although Mr. Harris was not involved in the FDOT contract procurement process associated with this consultant, during the period from July 11th, 2018, after the FDOT employee that had procured that contract left public employment and the responsibilities of managing or overseeing that contract were transferred to a subordinate employee of Mr. Harris, and October 4th, a period of mere weeks, Mr. Harris was the supervisor of an employee who had that FDOT contract with Eisman and Russo as part of his responsibilities. And thus, under this provision, 112.31854, the contract was within his responsibilities prior to his leaving public office. During this period, his responsibilities were limited solely to managing that subordinate employee, attending 3 meetings with the consultant, and signing one single action request associated with that contract. Thus, if 112.31854 were applied in isolation, it would provide that because the FDO contract was within his responsibilities and that of his subordinate, during this period of weeks preceding his leaving public employment, he would be prohibited from working for Eisman and Russo for a period of 2 years for the date he left public employment in connection with the FDOT contract associated with the road widening project. This would be particularly onerous for Mr. Harris, who will give you some perspective on the impact if applied in isolation. Luckily here, though, the Commission, in construing the post-employment provisions of the Code of Ethics, has found that in certain factual circumstances, it is necessary to apply the equitable remedy that is contained in Section 112.316. This section provides, in pertinent part, that it is not the intent of the Code of Ethics to prevent a public employee from, quote, accepting other employment or following any pursuit which does not interfere with a full and faithful discharge by such employee of his or her duties to the state, end quote. In prior opinions issued by this Commission, including CEO 95-19, it has been applied to ameliorate the literal application of Section 112.3185, subsection 4, and find that an employee under certain factual circumstances was not prohibited from being employed by an entity that is contracted with their former employer and whose contract was, in part, within their responsibilities while publicly employed. Staff believes and recommends in the opinion before you that it would be appropriate to apply the provisions of this equitable remedy to the facts in the instant case and thereby negate the conflict of interest, because the facts here indicate that the FDOT contract with Eisman and Russo was negotiated, entered into, and signed by persons other than Mr. Harris, and that the involvement of Mr. Harris with respect to the contract occurred during a brief period between July 11, 2018 and October 4th, 2018, and was limited to those activities which I just mentioned, attending 3 meetings, overseeing the employee, and signing a single action request, which is largely perfunctory in nature. In light of the foregoing and in accordance with Commission precedent, the staff draft analysis recommends application of Section 112.316 to negate the post-public employment restriction and enable Mr. Harris to continue his current private employment with Eisman and Russo, which in part would require him to have some limited involvement with the road widening project during the 2 years following his leaving his public employment on October 4th. This opinion is hereby submitted for your consideration, and staff and Mr. Harris are available to answer any questions that you might have.
Thank you, Ms. Kleinke. Any questions for her? Thank you, Commissioner Richter. Give me just a moment, and I'll come back to you. I believe we have Mr. Harris here with us today. Welcome, sir. I understand that you have expressed a desire to address the Commission. I would simply point out to you that you've got a recommended advisory opinion here that threads the needle quite well for you, and so you may not want to talk us out of it, but be happy to hear from you, sir.
Thank you, Chair, and good morning, Commissioners, Chair, and Madam Executive Director. Thank you for allowing me the opportunity to submit my request for formal opinion to the Commission and provide a brief statement on this request. I worked for the Department of Transportation for a little over 15 years, holding several positions and working my way up through the organization to construction manager, which was the position I was in upon my vacating employment with the department. The reason I feel so strongly about this consideration, I had no involvement with the contract during any procurement phase. I supervised an employee during a period of time when nothing was happening, and terminated employment prior to any work on the contract occurring. I attended 3 meetings, signed 1 action request, which was just a formality required by the department. I understand the importance of Florida Statute 112.3185 and agree with its intent, which is to keep state employees from creating a need for a contract, procuring said contract, negotiating pay rates and man hours for a position beyond which is considered to be normal, and then leaving public employment to accept that position at a higher rate with more hours than is needed, basically abusing that employee's position and the trust of the taxpayers of the state of Florida that they have put in that position. As you can clearly see, this is not what happened in this case, and besides a brief term of supervising an employee during a period of which was insignificant at best, I had no interaction at all that would put me in a position to abuse that position or tarnish the trust the taxpayers of the state of Florida held in me during my 15 years of impeccable career to public service. In closing, I would again like to thank each commissioner for allowing me to submit this formal consideration, and I sincerely request you accept the staff's recommendation. Thank you.
Thank you, Mr. Harris. Any questions for Mr. Harris? All right, sir. Thank you very much. Commissioner Richter, I think you had a motion. Are you still there?
I'm not sure. Oh, yes, I'll make a motion.
Second.
We have a motion and a second. I believe that was to approve the recommended advisory opinion as drafted, and it has been seconded. Is there any discussion on the motion? Seeing none, we will call the question. All in favor of the opinion as drafted, please say aye. 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 Any opposed, nay? The motion carries. Commissioners, it's 10 o'clock. We're at a little bit of a stopping point here. Why don't we take a 10-minute break, and we'll reconvene about 10:10. Anyway, I think the only time I tap it is to reconvene. So anyway, we are now proceeding with item 8 on our public agenda for the day. This is consideration of financial disclosure appeals. Before we do so, though, I will take a quick moment of personal privilege. One of our new members, Ms. Lesnoff, wasn't able to be with us right at the beginning of our meeting today, and as mentioned to Joanne and to Tony, our other new member, we start out our meetings, our public meetings, with our new members and ask them to introduce themselves and say a little something about themselves. So I'll do that now. So Joanne Lesnoff, welcome, and please tell us about yourself real quick.
Thank you, Commissioner and Chairman and Commissioners. It's a pleasure to be here. I apologize for having to be late today. I want to first off thank Speaker Corcoran. I'm grateful to him for this appointment. I think the work here is, of course, vitally important. I'm a newly retired state employee, and so far I have to say the pay is not quite as good, but the hours are fabulous. I spent 31 years in state government, roughly 2/3 of that working for the executive branch and 1/3 working for the legislative branch. My most recent service was for the legislature, working as the staff director of the House Appropriations Committee. I did that for 10 years. Prior to that, I worked in the executive office of the governor, working on policy and budget-related matters, and prior to that, I worked for the Department of Corrections. I'm happy to be here, and I look forward to working with all of you. Thank you, Mr. Chairman.
Thank you, Commissioner. Welcome. Glad to have you. You ask and you shall receive. There we go. So, Commissioner Carvajal, please.
Thank you so much. I appreciate also the opportunity to serve at the request of Speaker Corcoran and joining this august body that I've experienced mostly from the outside before. Get to see many of you for the last 25 years. I've been working in the nonprofit domain. Last decade, roughly, with the Florida Chamber Foundation. Most of my work is actually on the visioning projects and talking about everything from talent to volunteerism and quality of life. So it's nice to be on the ground level conversations, and I appreciate the welcome and the insight so far.
Thank you. Welcome. Glad to have you both. All right, we will now proceed with item 8, consideration of financial disclosure appeals. Commissioners, item 8 on the agenda consists of the appeals of automatic fines under the financial disclosure law. There's only one appeal in which the appellant has asked to be heard. We will take that one up first, and then we'll consider the other appeals. The one for which a hearing has been requested is Appeal Number FD 2017-120. Melissa Rutland. Is Ms. Rutland or her counsel present? Please come and identify yourself for the record.
My name is Melissa Rutland.
All right. Thank you, Ms. Rutland. We will be right with you. We want to hear from members. Do we want to hear from staff on this matter? Lane Johnson, I believe, has this matter. And Mr. Johnson, what say you?
Well, what I say is normally this appeal would be waived because she didn't get the initial things, the Supervisor for Election Center, the notice of delinquency and so forth. But the problem is on March 6th, she received the notice of assessment of automatic fine and signed for that. And that gave her till April 2nd to file an appeal. And she, for whatever reason, was unable to file an appeal before April 2nd or until a few months afterward. So mostly the problem is the untimeliness of the appeal. That's the only, the real issue here.
Thank you, Mr. Johnson. Any questions for Mr. Johnson? Ms. Rutland, what would you like to say?
Good morning, Commissioners. Thank you for your service today. It's an honor for me to serve my community in my public capacity. And in 2016, when this forum was for, I was serving in a alternative capacity as an alternate member. And this whole thing was an error and not maliciously done at all. My business was greatly affected during Hurricane Irma. And it was not until July that everything normalized for me, which is when the appeal was filed. In 2015, I timely filed prior to the expiration. And in 2017, I filed in February, actually this year, when it was due in June. They hadn't even mailed out the forms yet. And all of these things that happened that led to to where we are today was just a perfect storm that came together of a combination of unfortunate circumstances. As I'm in real estate, and the deal was supposed to close the week Irma happened, and they had a wrong address for me, and so I wasn't receiving any of these documentations. And so things between that and the evacuating my home, not being in my home practically the whole month of September, and when I came back to normalization in November is when I was able to file the form. And I take these kinds of things very seriously, and being transparent and timely is just a very important thing for me. And I appreciate you having consideration, and I just ask for your mercy for this first-time offense and waiving this fine, please.
Any questions for Ms. Rutland? Okay, seeing none. Thank you very much. Appreciate your input.
Thank you, sir.
All right.
Appreciate you letting me be here.
Thank you.
Should I sit?
You're welcome to have a seat. Yes, ma'am. Thank you. All right, Commissioners, we have a recommendation from staff, and you've heard from the parties. Do we have a motion?
Comment? Coming from Southwest Florida, Irma did tremendous damage, both emotionally and physical, in our neck of the woods. And I know it was very disruptive in a lot of people's lives. Just like Michael has been here too, we deal with these things. I think I buy the discussion that Irma, and it enhances itself when I find that there's a wrong address at one point in this whole process. So I would find favor with the appeal request by the complainant or the respondent, rather, and make a motion to dismiss, or however, would that be an appropriate motion?
Madam Chair. Madam Executive
You
Director.
can make a motion to reduce the fine. You can make a motion to waive the fine entirely. I think the point that Mr. Johnson was trying to make is that she was told in person on March the 6th of this year, that she had until April 1st to file an appeal. Or April 2nd, and she did not file the appeal until July 20th of 2018. So that's, the IRMA may have been a factor in the initial failure to file, but I think what he was making the point was that the untimely appeal was the rationale for the denial. But you could make a motion to waive, or you could make a motion to reduce the penalty to any amount you want.
Mr. Chair, may I ask a question?
Another question, yes.
Just so that I'm clear on the wording used, I think the staff report suggested that this would normally have been waived if it had been filed timely. Is that what I heard you say?
That's correct.
And just so that I'm clear again, and don't make the same mistake, if it would have been waived before, is that the same thing that potentially Commissioner Richter is asking for right now? Waiving, if this had been fined timely, we would have waived it and there would have been no fines or penalties. The only reason it's before us is the timeliness after the deadline for appeal.
Yes, yes. And receiving notice of that deadline on the 6th is the
Thank you.
issue.
Commissioner Richter.
Yeah.
Oh, I'm sorry, Commissioner Brady. Okay.
I think that the appropriate belief is that the commission would have in all likelihood waived the fine if the fine had been, if the appeal had been done on a timely basis. Whether or not it would have waived it would have depended on whether or not we felt that the various reasons that people presented were appropriate for it. I mean, I think the concern is that in April or March, somebody talked.
It was March 6th is when she received it.
Responded, said to her, listen, you know, say, oh, geez, we understand that. Hurricanes are terrible. But you need to at least send us a letter telling us why you weren't able to do this. And in all likelihood, if she had done that at the time, people probably would have said, yeah, fine, that's a good reason. But to actually take then another 4 or 5 months to be able to respond, I think is somewhat out of the ordinary. I mean, I would have moved to basically approve with a reduced fine, simply to have a reflection that, yes, indeed, there are probably some issues. But the truth of the matter is, Hurricane Irma was a long time ago. And though we need to understand that it caused sets of problems for people, it needs to be more than, gee whiz, I just couldn't get around to it, to do what I am required to do.
Okay, Commissioners, we've got a lot of discussion and no motion. I need a motion.
I'd like to move to waive the fine.
Second.
Okay, we have a motion and a second to waive the proposed fine. So let me make sure I understand the ramifications of this. And Mr. Johnson, you may have to help me with that and as Executive Director. But if I'm following the motion correctly, it would be that we find that the appeal is untimely, yet nevertheless waive the motion. Is that the motion?
Move to waive the fine.
All right.
I'll take guidance from the Executive Director on how
Me
that
too.
goes.
The way I hear the motion is that notwithstanding the untimeliness of the appeal, the fine should be waived. That's the motion.
That's so well stated. I thought I said the same thing, but.
That's where I heard it.
Oh, okay. Commissioner McManus, yes, sir.
Yeah, it's kind of a point of order. Do we have absolute discretion to ignore deadlines for appeals? In other words, do we have jurisdiction even?
Spoken like a judge.
First question.
Executive Director.
That's an excellent question, and in the past, when we received untimely appeals, your staff simply advised the person that the appeal was untimely and would not be heard. And we did some research last year based on, except when the appeal was based on, when the untimeliness was based on lack of notice. In other words, I did not get notice of my appeal rights, and so I now am appealing, and you should let me appeal because I didn't know what the time limit was. So that being said, we looked at that, and we did not feel comfortable at the staff level telling people that they could not appeal because it was untimely. This is a case where in the past, I mean, we know for a fact she had notice because she talked to our staff. And she talked to our staff after she got the notice saying, you're getting a fine. If you don't appeal, you're gonna have to pay this fine. So in the past, we would have simply told her, your appeal is untimely, it won't be brought. But having done some research on it last summer, we sort of changed our internal policy so that that would be the commission's decision rather than an administrative decision.
So I guess the answer is
Yes.
that we do have the ability to ignore the deadline for appeal.
Commissioner Rickey.
Expand on my motion and the rationale. I move that we waive the fine, accept the tardy appeal, and waive the fine given the circumstances, the hurricane, the ongoing drama associated with the hurricane. Some people recover from hurricanes faster than others because of physical damage, emotional damage, and the fact that some of the notices have been returned to sender. And so with that as a rationale, I would move that we recognize the appeal was filed late and that we waive the fine.
Okay, any other discussion on the motion?
Yes, please.
Yes, Commissioner McManus.
I forget whether I read it or not. Was there a 2016 form ever filed?
Yes, there was, but it was filed a long time later on.
Okay, so it was filed.
Okay. I believe it was filed, here we are. It was filed July 23rd, I believe, of 2018.
No. Paragraph
Oh, wait,
6 of the order.
I'm sorry, I was talking about the fine appeal form. Yes, that's correct. That is correct.
Yep. That's correct.
I'm sorry, I was referring
November
to
2000.
the actual appeal form itself, not the CE form. But yes, that is correct, it was November.
Any further discussion? Commissioner Berger.
Here's what's kind of
Oh, there it is.
rolling around in my brain that I'm pondering. A hurricane is a legitimate excuse, and I understand, and I'm listening to them. That's not what I'm keying in on, that it was late. It's that subsequent to that, 109 days lapsed in which the appeal was late, and now we're having this hearing, and someone had to draft up paperwork and do up paperwork so that we have to be here today. So, you know, the fact that I don't have any problem, there's a couple sentiments that have been passed on the board about reducing the fine, which I certainly don't have a problem with, but I don't know about waiving the fine because the appeal was filed 109 days late, therefore causing us to have this hearing today and then have to investigate this portion of it.
Any further discussion? Commissioner Meggs.
I just, you know, and I don't know where I got this from. I've read so much in the last week, but I wrote on my notes here that, of course, that the appeal was not timely filed, and I wrote that there was no grounds for it anyway, for an appeal. So I'm kind of not in favor of just letting this go by the wayside.
Any further discussion? Okay, Commissioners, we have a motion. The motion is to recognize that the appeal was untimely, nevertheless to waive the $1,500 statutory fine. All in favor of the motion as stated, please say aye.
Aye.
All opposed, nay?
Nay.
I believe the nays have it. Does anyone from the aye side want to have a roll call? Okay, the motion fails. And I will entertain another motion.
Then I would move that we recognize the late appeal and reduce the fine to $100.
Is there a second?
Apologize, second for that, for conversation and clarification. Thank you.
Okay, seconded. For the purposes of discussion, I'm going to call on you, Commissioner Carvajal, to have that discussion.
Thank you. And I guess the questions are, what are the ranges that we have authority to? Is it everything from maximum to zero? Is that what we're trying to say here?
0 to 1,500.
0 to 1,500 in this case. And then,
And
thank you.
it's $75 a day, just to give you a time frame.
25.
Oh, 25, sorry.
Thank you. And then,
I know the inflation's gone up some.
so I think that somebody would have eventually made the motion at a certain level, and I guess I wanted to make sure that folks had a reasonable opportunity to talk about the rate. Thank you.
Okay, so we got a motion at $100. Going once. Yes, Commissioner Brady.
Amend the motion to set the assessment at $500.
That's where I was headed to.
Okay, so we have a discussion of a suggestion of an amendment to the motion to change $100 to $500. Beginning to feel like an auctioneer. What say those who made the motion and seconded it?
Looking at the respondent's letter here, it says, "It never occurred to me that I could incur such large fines for a volunteer position with the city I love." Given that statement and given the hurricane, that amendment was not accepted.
Okay, the amendment is not accepted. So the pending motion is before the commission at acknowledge the late appeal, $100 fine is the motion. The question has been called. All in favor of the $100 motion, please say aye. Aye. All opposed, nay?
Nay.
Nay. The motion fails. If anyone wants a roll call, let me know. I think that clearly failed. Do I have a motion on this matter? Commissioner Brady.
Move to adopt the late appeal and lower the fine to $500.
Second.
We have a motion and a second for $500. Any further discussion concerning the motion? Seeing none, call the question. All in favor of the motion, please say aye.
Aye.
Any opposed, nay?
Nay.
Okay, I believe the motion carried. Since we think we got one that carried, let's do a quick roll call.
Aye.
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 No.
Aye.
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 Oh.
Thank you very much. All right, so Ms. Rutland, the fine was reduced to $500. So thank you very much for your attendance today, and we appreciate your service to the state and your community. Thank you for coming today. Mr. Johnson, thank you. All right, Commissioners, the next matter are those financial disclosure appeals for which we have no request for a hearing. If there are any of these matters that a member of the commission wishes to set aside for consideration, please advise. Otherwise, do I have a motion on how to handle these en banc?
Move to approve the final orders en banc.
Second.
We have a motion and a second. Any discussion? Seeing none, all in favor, please say aye.
Aye.
Opposed, nay. Motion carries. We will proceed now to agenda item 9, final orders on financial disclosure fines, where there has been no appeal and no payment. Item 9 on the agenda involves persons whose disclosure statements were filed late or not filed at all, and who did not appeal the assessment, fine, or pay the fine. These cases are before you for the adoption of final orders imposing the fine. Are there any questions from the members? Seeing none, do I have a motion?
The motion is,
To approve the final orders on financial disclosures en banc.
No, we just did that one. This is item 9, consideration of financial orders, final orders on financial disclosure, right?
my understanding is this is really an information item. Is there any action to be taken?
No, I make the motion they approve the final orders on financial disclosures en banc.
Yes, action is to be taken, Commissioner Brady, in response to your question.
Any other motions?
We have a motion. Is there a second? Motion is to approve. Is there a second?
Second.
We have a motion and a second. Any discussion? Seeing none, all in favor, please say aye.
Aye.
Opposed, nay. Motion carries. All right, we will proceed to reports. Chair's report. We welcome our new members, and glad you are here and joining us, and look forward to serving with you. And then we, of course, as always noted, our executive director will have a report. So I'll turn it over to you, Madam Executive Director.
A very short one. In addition to our new members, we are welcoming a new staff attorney. Deanna Ramming comes to us with a extensive criminal defense background. So she brings a perspective that we don't ordinarily have around here. But we are going to indoctrinate her into the ways of administrative law post haste. We're very happy to have her. Also, members, you need to know you might have noticed Amendment 12 passed in November. This is the amendment that changes Article 2, Section 8, which is the ethics article in the Florida Constitution. Among other things, Amendment 12 calls for the commission or says that it will be prohibited for officials to abuse their positions to obtain a disproportionate benefit for themselves or certain others. And it tasks the Ethics Commission with coming up with rules, administrative rules, defining the term disproportionate benefit. And we have to do that by October. So, as not to lose any time, we are starting with rule development workshops. These will not be in conjunction with commission meetings. These are just for staff and any affected person that wants to have input. They've been noticed in the Florida Administrative Register, also on our website, and I will state the dates for anybody listening. January 17th, February 8th, and March 15th at 10 o'clock. And we are interested in anyone's input. So if you members have any, or if you hear from your friends or members of the public, please pass their ideas on to us. I think it will be a significant challenge to define that term, and we are all ears for anyone's good ideas.
Is the amendment on the website, on our website?
You know, I don't think it is. I'll make sure.
Yeah,
Put it up there.
at least so we can look at it.
Good suggestion.
Move to adjourn?
Well,
I'm sorry.
in just a moment. Thank you.
Okay.
Ms. Ramming, welcome. We're so glad to have you. Heard a lot of great things about you and look forward to working with you. Commissioners, we have a motion to adjourn. Sounds good to me. All in favor? Aye, please.
Aye.
Any nays? All right.